First of all, I want to say, in terms of Cherokee civil rights, this is the most important case we have seen in modern Cherokee history, just hands down, okay, with respect to Cherokee civil rights. I was involved in that process from beginning to end, that drafted our present-day Constitution. When that amendment was passed, there was at that point over approximately 2,500 freedmen enrolled, and that operated to disenroll them or disenfranchise them. They had appeal rights, as any Cherokee citizen does. If their membership is taken, they can appeal it before the district court. At that time, it was District Court Judge John Cripps agreed with our position and said the freedmen could not be disenfranchised even through a constitutional amendment, because they had inherent rights vested through the Treaty of 1866. At that time, the Supreme Court said, well, we're a constitutional court, we're created by the Constitution, and this is a constitutional government, and if the people choose to pass this amendment, we have no authority to overturn it. In essence, that's what they said. You know, what started way back in 2007 has finally come full circle to see the freedmen enjoy not just some rights, not just citizen rights, but all rights of native Cherokees, because that's what the treaty provides for, that they were to be adopted into the Cherokee tribe. Not just the freedmen, but also the Delaware and the Shawnee, equally so. We have a history, unfortunately. We're not the only tribe that does. People are shocked to learn that all 5 of the, quote, civilized tribes owned slaves. And that's just a historic fact. It's a sad fact, but it's a fact. And all those tribes were asked to adopt those freed slaves, known as freedmen, and their descendants into their tribes. Now, this shouldn't be shocking, because the same requirement was made of every southern state that had joined the Confederacy. And that was the case all the way up to statehood. Well, of course, it stopped at that point, but actually it really didn't stop. They still tried to continue to resist it one way or the other through the years. And of course, you know where they get that. The by blood comes directly from the Dawes rolls, where there was separate rolls set up for Cherokee Delaware, the freedmen, intermarried whites, and Cherokees, quote, by blood. And the answer I got is the Cherokees insisted upon it. Okay, well, that in and of itself is not necessarily, discriminatory. But what was and what made it discriminatory was the fact that the Dawes Commission made absolutely no effort to even ask freedmen whether or not they had any Cherokee blood in them. It was literally done in a very racist fashion. If you look like you're African American, you are not permitted to sign the Cherokee rolls. You had to go over and get in that line and sign the freedmen rolls, where they never even ask you if you had any Cherokee ancestry. And that's one of the most biggest inequities of the entire Dawes Commission process and the enrollment process, because the freedmen that I visited with, and I visited with many, The historians that have researched the freedmen's plight that I've visited with, I've asked this question: how many, if you could give me an estimate of how many modern freedmen today that has some degree of Cherokee blood in their heritage, what would your estimate be? And the estimates I get is 60 to 75%. So that is one reason to say that we're only going to let by-bloods hold office is totally inequitable and offensive racially, because there are many, many freedmen that do have Cherokee blood in them. It was just never documented. And they can prove it historically, but it was never recorded during the enrollment process, and that, through the acts of Congress, that has become the gold standard for membership. Under our Constitution, we are subjugated to federal law, as is every, American Indian tribe. So we cannot do anything that violates federal law. That case was decided by a federal court, and it was not appealed up to any higher appellate court. So it is binding on the Cherokee Nation. And the reason it's binding is because Principal Chief Chad Smith and the council, back when all this came about, I can't remember exactly what year it was, but it's in the decision, they expressly passed a resolution waiving the sovereign immunity of the Cherokee Nation so this litigation could proceed, and essentially bound the nation to its outcome. So their citizenship rights stem from more than one source. My rights as a Cherokee citizen stem from our Constitution, okay, because I meet the qualification. I'm a descendant of one of the original enrollees, okay, as most. However, the rights of the freedmen and the Delaware and the Shawnee, they have that, but they also have the guarantees of that Treaty of 1866. And that cannot be ignored, amended, or abrogated by a simple vote of the people. And that's what our high court found, is that because their rights are derived from more than one source, and one of those sources carries the force and effect of federal law, Cherokee people do not have the power to overturn that. And in terms of a referendum vote, they just don't. And that treaty, as all treaties are, carry the force and effect of federal law. See, they're ratified by Congress, so they carry the force and effect of federal statute. And the Cherokee people cannot pick and choose what parts it likes or it's going to recognize or not recognize. If you take an objective approach to the legal history of the freedmen, starting with 1866 and moving forward, every time they've been challenged in a court of law, or their rights have been challenged, they have won. Each and every time, not just part of the time, every time. This is just the most recent incarnation of that. I mean, I'm to the point now, because it's already been decided that they have rights under the treaty that the Cherokee people have no power to diminish. It's already been decided at the federal level. It's been decided by the highest legal authority in the Cherokee Nation. So I'm not sure what other arguments could be made at this point. Literally, I don't know. So with respect to their rights as Cherokee citizens, I think the question has been fully answered. I do.